welcome to this web exclusive interview with family law lawyer and mediator Michael Butterfield. Michael, we were talking about mediation on the program, and it does, by and large, have quite a high success rate, doesn't it?
The success rate is probably around 85–90%, and even in the cases where there's not complete success, quite often you're able to resolve a lot of the minor issues. That's very important, because if you don't have complete resolution, you're going to have to move on to another process, and the less that you can fight and argue about, the better. Yes,
I mean, you know, if you can't agree, let's say, on an access schedule, but you were able to agree on the support, the division of property, you've still eliminated a lot that you have to fight about in court.
And quite often what you see when people don't use the mediation type process or an ADR process is that they go to court and everything is on the table. So what could be settled in a one-day trial or a one-day arbitration becomes a 4 or 5 day trial, because everything is up for grabs, and that really doesn't serve anybody's interests.
And one thing that really impresses me as a judge is that the satisfaction rate among the spouses after completing mediation is so much higher than the zero satisfaction rate that most people have after leaving court. It seems as if they learn through that process how to problem solve, even in the future, if issues come up.
The education component of mediation is very important, because the parties learn how to recognize the triggers, and they also learn how to resolve issues between themselves. The problem with court, with all due respect to your Honour, is that the judge is the third-party arbiter, makes a decision, doesn't know the parties, doesn't know the circumstances, doesn't know the children, if there's children.
And the parties have just given up all that power to a judge.
They've given up all the power.
Completely. It's totally unpredictable, really.
Mediation gives them the ability to take back that power, to control their own destiny, to have a voice in the process that they don't have in the court, because quite often the only people who do the talking are the lawyers.
And I find that in mediation, you're not necessarily bound by the same rules that a judge would be bound. You could be more creative.
Absolutely. I mean, in the legal system, there's a winner-take-all approach. There will be a winner, there will be a loser. In the mediation, there's often both parties have given ground on something, but have got what's important to them.
Well, I tell people in family court, there are no winners. There's only degree of losing. But I do want to cover the issues of what happens if mediation doesn't work, because it doesn't work for everyone. So let's say that two parties have tried really hard to negotiate, and for whatever reason they just can't agree. What happens then?
Well, the traditional approach is that you then go through the litigation stream, which is expensive, time-consuming, and can take many, many months, if not years, to actually get before a judge. We've now seen in a lot of jurisdictions across North America the development of arbitration, which is in essence a private judge. I recently qualified as an arbitrator, and it's an exciting development, because what it does is it's cost-effective, it's quicker, and most important of all, it's confidential.
So just to make it very clear for our viewers, if two parties have agreed in advance that they will mediate, they're going to try with a mediator to work out a solution, and they can't, they have already authorized the mediator to now put on a different hat and become an arbitrator and make the decision.
There's two ways of doing it. You can go into the process where you say it's a med-arb, which means that there's going to be a mediation, and what's not settled then becomes, the mediator becomes an arbitrator. Or you can complete the mediation, settle what you can, and then move on to an arbitration. The advantage
with the same person.
With the same person.
What I like about that is that person already knows everything you've already said.
Yeah.
I guess my only question is, what if the behavior during the mediation wasn't that great, and you are now going to be the arbitrator, and you are going to use some of that information you heard to make the decision? Isn't there some worry that you might be biased?
Yeah, that's the biggest sort of risk with this. So what we offer in our practice is we offer the ability to, if the parties aren't happy with the mediator becoming the arbitrator, then they can select another arbitrator, someone who's not heard what's already been said.
And even if they do that, they have to pay for it.
Yes.
I mean, when you go to court, it's free. At least the judge is free.
There's a lot of wait time in court.
Yes, but it is free. I mean, you don't, if you represent yourself, you fill out the paper, it's free.
Yes.
But, like you said, it's time consuming, it's very unpredictable. If you go to an arbitrator, you both have to agree on this person.
Yes.
And you agree to be bound by that person's decision, and you have to pay them. So what's the rough a rough estimate of what it would cost?
Well, it depends on the number of issues, but you're probably looking at between $3,000 and $5,000 a day for an arbitration. But an arbitration, whereas court starts at 10, ends at 4, and has an hour and a half for lunch, an arbitration generally will start earlier in the day, end later in the day, and is a lot more focused. The other advantage of arbitration is you're not bound by the same rules of court. So a lot of evidence can come in by affidavit, subject to cross-examination. There's certainly arbitrations where you don't even have oral testimony. It's all done on affidavit, similar to chambers proceedings in Supreme Court. So there's a lot of speed and efficiency that's gathered by removing yourself from the ceremony of the court proceedings and by giving yourselves the ability to control the process.
Well, I want to thank you very much for educating us on mediation and arbitration. There you have it. If you don't want to go to court, choose your own judge. Thanks very much.
Thank you.